Hello, everybody. So in today's video, I'll be discussing the case of Engie, which was pronounced in December 2023. This is a EU state aid case. This is another judgment in a series of state aid rulings, such as Apple, Fiat, and Amazon. So on December 5, 2023, the CJEU overturned the judgment of the General Court, which upheld the Commission decision of June 2018, finding that Luxembourg had granted unlawful state aid of euro 120 million to Engie. This ruling confirms the limits on the European Commission's use of state aid rules to challenge investigation of the tax rulings. As we know that Article 107 of TFEU prohibits state aid, which concerns aid measures that grant a selective advantage to certain undertakings over others and thus distort competition. So if you're interested to understand more on the provisions of state aid, you should definitely refer to Article 107 and 108 of TFEU. Now, coming to the brief facts and background of the Engie's case, in 2018, the Commission found that Luxembourg had granted unlawful state aid to Engie through two individual tax rulings, which enabled Engie to avoid taxation on almost all the profits of its Luxembourg subsidiaries since 2008. The Commission found that the tax rulings granted a selective advantage within the meaning of Article 107 TF of the TFEU because they afforded a favorable tax treatment to Engie compared to the normal tax regime applied by Luxembourg without any justification. The European Commission gave three reasonings to claim that Engie had received a selective advantage. So in the first line of reasoning, the European Commission claimed that Luxembourg law did not permit to deduct expenses to the extent they give rise to a corresponding exempt income. So as a result, the parent entities that were not taxed upon their disposal of the conversion shares had received an unlawful selective advantage. In a second line of reasoning, the European Commission sought to demonstrate a selective advantage at the group level. In a third line of reasoning, the European Commission argued that Luxembourg should have applied its general anti-abuse rules to reject the ruling requests and prevent the selective advantage. Now, the parties challenged the Commission decision before the General Court, which upheld the Commission's decision in May 2021. The General Court essentially confirmed the Commission's findings that the two tax rulings, they granted a selective advantage to Engie as they afforded Engie a tax treatment that departed from the reference framework as broadly defined by the Commission, and that the Luxembourg Tax Authority should have applied its tax avoidance rules. The parties thereafter further appealed to the European Court of Justice. The CJEU set aside the General Court's judgment and annulled the European Commission's decision, rejecting all the lines of reasoning which were raised by the European Commission. The CJEU found the decision wrongly defined the reference framework, which is the first step in assessing the existence of a selective advantage. The first line of reasoning was set aside by the CJEU on the ground that the European Commission misinterpreted Luxembourg law and adopted a wrong reference framework by referring to the general purpose of taxing all resident companies without properly assessing the wording of Luxembourg law. As regards abuse of law, the CJEU found the General Court and the European Commission were wrong to dismiss the administrative practice of the Luxembourg tax authorities in applying this provision and consequently required the setting aside of the general court's judgment and annulment of the commission's decision. Now, coming to the impact of this particular judgment. So, as we know that this is in a series of judgments on the state aid. So, on July 15th, 2020, the General Court annulled the Commission's landmark decision against Apple. On November 8th, 2022, the CJEU set aside the General Court's judgment and annulled the Commission's decision concerning Fiat. Further, in December 2023, the ECJ upheld the General Court's judgment that annulled the Commission's decision, concluding that Luxembourg granted unlawful state aid to Amazon. I have already uploaded a video on the Amazon state aid ruling of December 2023. You may refer to the same if you want to understand this concept of state aid in more detail. So, somebody who is interested in learning this concept of state aid and following all the rulings, you may refer to all the rulings which I have just mentioned here on this particular slide, as well as this Engie's case. Thank you so much for watching this video, for listening in. These rulings are especially important for all the learners of international tax who are doing ADIT or diploma in international tax or LLM in international tax, as well as any professional of international tax who is interested to understand more or into the concept of state aid rulings. So I really hope that you find these videos useful. Do leave in your comments below or feel free to write in to me. My email ID is provided on the slide. See you soon. Bye-bye.